So the case seemed to have been something that really hit the patent office quite a bit, as well as industry, because there was a flood of patent applications covering this type of inventions. We'll see in a little while that somehow or other, some people said the patent office was somewhat caught off guard. In fact, they were in Amazon.com. Before I go to Amazon.com, I'd like to now just describe some of the distinctions now that we between copyright protection of computer programs and patent protection of software-based inventions. Copyright protection excludes methods, processes, and utilitarian features of computer programs. On that basis, we saw, for example, that when it came to literal copying, the court seemed to be pro-plaintiff. When it came to the non-literal elements of a computer program, structure, sequence, and organization, the courts seemed to be pro-defendant in copyright cases. In patent cases, patents specifically include methods, processes, and utilitarian features of an invention. Now, both copyrights and patents require creativity. In copyrights, recall that the creativity is original work of authorship. When it comes to patents, the creativity requires that the invention meet the tests of novelty and non-obviousness. Now, before we go on to Amazon, I just wondered, I'd like to think that I've answered some of your questions, but the candor forces me to admit I haven't. Does someone have any questions, and then we'll go on to Amazon.com, or is there some topics here that we're not quite clear? Please.
Something like a user interface is covered by patent. For example, when the Mac came out in 1984, there's this way of dragging files into a trash can. Windows comes out with a recycle bin. Should Apple have, I don't know what actually took place, but was that trash can idea patentable?
At that time, the courts would have been very hostile to that. Now, maybe what they may have done is just decided, don't bother filing. Let's just get let's copyright our computer programs and hope that if they copy any of the lines of code, we can catch it. Now, remember, catching someone copying lines of code, the courts tend to go in favor of the plaintiffs. In fact, if you look at the cases, what we often try to determine is how many lines of code must the plaintiff catch the defendant in copying before the plaintiff can get a judgment. I know, for example, like in Apple Computer versus Franklin Computer, there was 100% copying. Well, that case went in favor of Apple. In Computer Associates versus Altai, when it came to 3.4, Altai copied 30%, so that goes in favor of Computer Associates. So I was going to ask some of the students here if anyone had any sort of rules of thumb you've heard from talking to people about what is the percentage of the amount of code that the plaintiff must prove the defendant copied in order to prove copyright infringement. Does anyone here have any idea? Have you heard any discussions with people in the industry? I guess not. About a year ago, I was in a management meeting with one of my clients, and one of the executives mentioned, I heard that if you copy more than 10%, it's an and we went on to talk about, we were talking about patent protection. We got a couple of patents for the client, but when it came to copying computer programs, computer program code, I never got a chance to talk to her about it. She was a marketing executive, so that's the unofficial, you can't cite it, there's no authority for it, industry scuttlebutt. Someone here has something. A line, okay? Right, yeah, I think yes. Now, when I said a line, I think that in the interpretation of the code, probably the experts will come in and the defendant is going to say something like, I only copied one line, or his expert's going to say that. Plaintiff is going to come in and say, but you copied a whole segment, a whole sequence. Everything here has to fit together. So you've copied maybe 20 or 30% of the code. So in terms of a line, I think that you'll find that a lot of the experts are going to go one way or the other. I can't really tell you where the line begins and where the line ends, but they usually come in and say, this is where the line begins and ends, depending on which side of the case you're on. I was trying to apply what you're saying to some of the cases. I know that I made a decision not to go deeply into the SCO litigation. I know it's a topic of conversation, and I don't have, and also I don't have any cases on which to base it. But I understand that Richard Stallman had talked to you at one time about. Okay, the SCO apparently has contends that I think it owns the Unix and Linux is an infringement, and it's accusing just about everybody in the business of infringement. And there is no decision, so I want to state for the record while the camera is on that I make no, I'm not saying one way or the other which side is going to win or which side is not. However, I note that there has been quite a bit of debate about this in the press, and the only information I have is based on some press clippings, and the information that I have is only from those few publications that I read. And I think that, as you pointed out, like where does the line begin, where does the line end? There was a press clipping that I had. I'd hoped I could put my fingers on it pretty quickly, in which, okay, here it is. I know that if you believe Mr. Stallman, he doesn't like it. If you go to the other side, that they go one way. You can see the way these cases go. However, there was one press clipping I got which we talked about the issue. Where does the line begin and where does the line end? SCO claimed massive copyright violations of Linux. So far, though, according to an article in the August 11 Wall Street Journal, it has only shown one example to outsiders and only to those who have signed a non-disclosure agreement. That's the statement of a reporter. Keep in mind, not evidence in court. It's a reporter's statement. It was to a programmer in San Francisco named Ian Taylor, and Mr. Taylor described the infringing code as trivial 80 or so lines of software out of a total of 4.6 million in all of Linux. That didn't by itself do anything particularly important, and by which he says he could rewrite in an hour. I suppose if he could write in an hour, a Harvard computer scientist could probably do it in 10 minutes. But I don't know whether or not what he referred to. Your question is interesting. What was he referring to about these 80 lines? So where does the line begin and where does the line end? You know, SCO might say 80 lines, that's 4 million lines. He just says it's only 80. So I wish I could give you the definitive, ain't no about a doubt, it's statutory answer to where the line begins or where the line ends. But it's usually subject to the expert interpretations in court.